when people say things like 50-50 placement, is that a defined, a precise schedule? What does that look like?
No, it's actually not. And I think people are.
Hello, everyone, and thank you for joining us today. My name is attorney Holly Mullin, and I am the managing partner at Sterling Law Offices. I have with me today attorney Nikole Messerschmidt. Nikole is a senior partner in our Madison office. Nikole, thank you so much for joining us today.
Hi, Holly. Thanks for having me.
And you have previously done these podcasts with me where you have shared really helpful insights based on your practice and your experience with family law. What I want to talk about today is custody and placement. You know, it's an emotional part of a family law case is figuring out what's going to happen with the kids. It's the most important part of a divorce case. And these words, custody and placement, get thrown around a lot, and we use them all the time. And it seems like a lot of people confuse these two words and they may use them interchangeably, but really they don't mean the same thing. And it's important that our clients and folks out there who are considering divorce or paternity action, that they understand what are these words? How are they used in a divorce or a paternity action? How are courts deciding on these issues? So maybe let's just start right there. What's the difference between custody and placement?
Great question. And I agree with you. I think it really does get interchanged quite often. People want to say that they want to share custody when custody is the legal decision making of your children. So where they're going to go to school, what doctor they're going to have, or can they get a driver's license when they reach the age of 16, for example? All of those major decisions that could potentially come up during the years that they're still a minor is legal custody.
So we're talking the major life choices, right? The way you're describing it is when you say things like school district and, whether a child can drive, these educational decisions, healthcare decisions, those are major life choices. We're not talking like bedtime or if that's a healthy snack or something like that, right?
Right, exactly. Those would be more like routine daily decisions that a parent can make on their own placement time, something that doesn't necessarily or potentially impact them on a larger scale, I guess.
Understood. And so specifically with regard to custody, when you say decision-making authority, so we hear people say, oh, I want to share custody. What does that mean?
Yeah, in Wisconsin, it's called joint legal custody. So both parties would have to make the decision together to be able to move forward. For example, changing a school district, right? If one parent wants to change a school district from District A to District B, and the parties have joint legal custody of their child, they wouldn't be able to do that without both parties saying, yes, let's change that district from A to B.
And the alternative to that would be where the parties don't have to talk?
I would hope not, right? Joint legal custody it's supposed to encourage parties to talk amongst themselves, write pro-con lists, right? Tell me the reasons why you want the move or the change, why you don't, and to have like a healthy co-parent relationship to try to sort out what is not best for that parent, but what's best for that child moving forward. If the parties have a sole legal custody type situation where one parent has the decision-making authority, then they get to decide. They don't necessarily have to consult with the other parent. They should still keep the other parent informed, of course, but they don't necessarily need the other person to weigh in and say, are you okay with this switch, for example?
Got it. Okay, so we're saying joint legal custody, the parents are engaging in these decisions together. Neither is making unilateral decision.
Yes.
Sole legal custody, one parent has the authority to decide. That's kind of what we're looking at here, joint or sole.
Yes.
What about placement? What is the definition of placement?
Yeah, placement is the physical time you get to spend with your child. So what's the schedule? Monday through Sunday, right? Where is that child with what parent, right? There's many different schedules, and initially when going through like a divorce, for example, the presumption is maximizing time with both parents, and sometimes maximizing time isn't always 50-50.
Got it. So when parents come in saying, I want primary custody of my child, we're interpreting that usually to mean they want physical time with their child. And so the word that they should be using really is placement. Like you said, it's the schedule, it's the physical allocation of time with your child. So when you said um, may not always be 50-50, tell me more about that. So when people say things like 50-50 placement, is that a defined, a precise schedule? What does that look like?
No, it's actually not. And I think people are mistaken that like the presumption in Wisconsin is like, or the starting point, right, is like everyone gets 50-50, which is not true. Like I said before, it's maximizing time with both parents. And sometimes maximizing time is, of course, shared equal, right? 50-50 time between both parents. But sometimes that's just not even feasible, right? Maybe someone has a different work schedule that they wouldn't be able to have a 50-50 placement schedule, but maximizing time looks something completely different with that parent.
Is there a scenario where, let's say the parents don't have odd work schedules, let's say they have perfectly normal work schedules, but it still wouldn't be 50-50?
Yeah, I think so. I think there's a multitude of different factors that could go into play. That's the statute sets forth many of that, right? Like what the parent wants, what the kid wants, what is, if there's a history of abuse, are there alcohol and drug issues, things like that, mental health issues, how the kid's doing in school, do the parents communicate well together and can co-parent, right? There's a multitude of different factors that could potentially kind of sway placement in one parent's favor, either minimalistically or a large part, right? Depending.
So you had said that the presumption for placement is that you're trying to maximize time with each parent. So really, I mean, the court does come in with the understanding that both parents are fit and appropriate to have time with their kid,
Right.
but there's also factors that can be considered that would sway them away from that. So if you have somebody, I think you referenced mental health and substance abuse, if we have a bunch of issues like that, it's going to perhaps move that scale in favor of the other parent who might be more stable and fit to care for the child. Is that a fair statement?
Yeah, that's exactly right.
Is there a presumption on custody? You had mentioned a presumption on placement, but what about custody?
Yeah, the presumption on custody is joint legal custody, that both parents are, as you mentioned, for placement, fit parents to make the right legal decisions for their child together and can communicate effectively in order to reach whatever decision is in their child's best interest.
And would it be the same factors then if the court is going to give one parent sole legal custody? Are they thinking about those same issues that you referenced for placement?
Yes, exactly.
Understood. Okay. And so I think we have clients who come in with some misconceptions and that, they have their own assumptions aside from the legal assumptions. They have their own misconceptions about what custody and placement is going to look like. Tell me about some of those that you've seen with clients.
Yeah, I think, sort of like I just alluded to, work schedules, right? Like people just really want shared equal, and sometimes it doesn't work out, especially with individuals that have school age children and then one parent works night shifts, right? Like that is very difficult to be able to a lot of times effectuate a shared equal placement. It doesn't mean that that parent is unfit to have 50-50 placement. It's just something that's not feasible and in the child's best interest given things that they need, throughout the day and even night.
Yeah. I've had clients who still seem to be under this old notion of moms automatically get custody,
Yes.
and I've had it both ways. I've had moms come in with that presumption. I've had dads come in saying, well, no court's going to give me a fair shake because I'm the dad, where we actually have a statute that precludes the court from considering gender bias. That's not a factor in consideration. So it sounds like these other factors that you rattled off, those are the ones that are going to matter, that folks going through this will want to have a real understanding of how it can impact their case. So how do these decisions get made, right? With custody and placement, ultimately there's going to be an order that comes through. How does that get determined?
Yeah, best case scenario, the parents are able to agree, right? Like, who better to know what's best for a child or children are the parents. So best case scenario is they're able to work it out together, what custody and placement and holidays and vacations and all of that stuff look like for their children. If not, the statute sets forth these kind of next steps, right? If people can't agree on custody and or placement. And the first is to go through court ordered mediation, which generally usually takes place through a family court services center within the county, and a social worker a lot of times, sometimes attorneys, right? But more often social workers are mediators to try to mediate those issues between the parties. That's kind of the first step. It's also a time saver, a cost, saver if the parties are able to utilize that setting to be able to reach a resolution by talking through certain disagreements to try to reach compromise.
Yeah. And if they can't,
Yeah.
if they can't reach a compromise, then
Yeah,
what?
of course, that happens. If they can't, then a guardian ad litem has to be appointed, which is an attorney that represents the child or children's best interest. And that guardian ad litem will do a thorough investigation into the case, interview mom, interview dad, any collateral sources, maybe new significant others or spouses, treatment providers, mental health providers, school officials, a lot of other people potentially, depending on the facts. And then based on the factors, kind of what we were talking about before, the best interests, they'll kind of run through an analysis based on all the investigation that they have gone through to be able to make a recommendation to both of the parents and the court as far as what they believe is in the child's best interest for custody and or placement.
Which they may or may not like, right?
Exactly, unfortunately, right?
Any final insight or words of wisdom for our listeners out there who may be facing a divorce or a paternity action?
I think always consult an attorney to discuss kind of what the facts and circumstances mean for yourself. I think it's always helpful to get insight from friends and family members, but their case may be very different from yours, so it doesn't always end up with the same result. So communicating with an attorney is going to be the best route to be able to decide the best path forward for you.
Great advice. So, I mean, it really does sound like we have these starting presumptions in the state of Wisconsin, but it's going to come down to the unique facts of a person's case, the needs of their child, the relationship that the parents have with the child. There's so many different considerations that are going to have an impact on the case that we have to look at the whole picture. And I always tell my clients too, try not to think of it as some sort of a zero-sum game that you're either winning or you're losing. It's like, this is really all about creating the best possible environment for a child.
Right.
And that's what the focus needs to be on. And that's what the court's focus is going to be on as well. So as always, Nikole, this is, it's enlightening to hear from you and your practical experience. So thank you very much for being with us today.
Thanks for having me. Appreciate it.
When custody and placement decisions get heated, the guardian ad litem's recommendation can make or break your case. And here's what most parents in Wisconsin get wrong. And it's usually too late by the time they realize it. So watch this next video and learn the #1 mistake that parents make with a guardian ad litem and how to avoid it.